case. So, Mr. Lett, we'd really like to know what
No
we've been
comment.
charged
I've
with.
told you no comment. Do not harass or stop.
Ma'am, I'm asking you questions. I mean, Deputy Love says we've been charged with 22-15 or 21-5922.
Why are you lying about us in court? We don't have that medical stuff.
You
know
disclosed
it.
the medical records,
you
not
disclosed
us.
it yourself, Jill.
Is
that allowed,
a pretty
Jill?
serious
You
You
offense.
guys
just
should
lie.
not be filming
Why
in
not?
a judicial
Oh,
area.
I thought it was
We're-
a
There are
court.
rules
Isn't-
not to
yeah,
film in
the court.
judicial
Yeah,
areas.
this is a
We're not in the
constitutional right
We're
that
like
you
right
guys down
outside
here
the
are gonna have
bathroom.
to understand.
I've told you I have no comment. If you don't stop following
We can
me, I
continue
will
to
charge
ask
you with
questions.
stalking.
You're gonna
We
charge
can
us with
continue to ask
stalking. You're
questions,
gonna
Jill.
charge us with
You lied
stalking.
about us in court. We'd like to know why.
Do
No,
not
no,
comment
no
on
charges
all
listed,
of
huh? So you're actually investigating us? Are you ever gonna tell us if we're charged, or is this just a criminal trial that happens without any kind of oversight at all? You just rule it yourself? Do you often lie in court? Judging from what we're hearing, it does seem that that's the case. You gonna share it with us? If I give you an upload link, will you share that with us?
Do you guys have any other questions for?
I do. I'd like to know about that duck.
Thank you.
Did you kidnap a duck, Jill? I hear you kidnapped a duck and threw a fit inside your house when the police came to get it back for the owner. Is that true?
Jill, is this stalking? Is this stalking? Did you know that the stalking statute says that it doesn't apply when you're conducting official business, especially in public? If you were trying to charge us with some bullshit charges,
Yeah.
asking you about it, and you said, quote, a charge of stalking now.
Flaunting your laws, huh? Don't pull the door on me, you dumb bitch. Don't pull the door on me. You called me a criminal, you dumb bitch. I'll call you whatever I want.
In the closing argument, I'll hear the state,
Plaintiff.
the plaintiff, and then I'll hear the defense.
Judge Huntley, if I can approach, I'll give you Exhibit E.
Is it marked?
Yeah.
Okay.
Yes.
Okay, thank you.
Judge, a couple of things. He's made a big deal over the fact that there are lots of other emails and stuff that came up in the beginning. The standard is a course of conduct, not the individual events that establish the fear. This is a course of conduct. It started months ago, and the conduct continued to ramp up until there was physical contact. I still believe he lunged towards that door. You can see him hurry across that landing and grab that door out of my hand as I'm shutting it. It did injure me, and if the video is watched, you can see that the point that the door comes out of my hand and it swings wide open, then I pull my arm up in pain, and you can see that in the video. I went ahead and took some time on my phone to log into my personal KBA account. Again, that's my personal account, to look up the preponderance of the evidence issues for the court issue we're asking earlier. I don't believe there's a light, most favorable finding made by any of the courts as far as how you view the evidence, that it is the legal and relevant evidence as a reasonable person might accept as being sufficient to support the conclusion. Conclusion of law is a standard review of unlimited when it gets to the court to review any conclusions of law. They mention 60-3106A, prove the allegation of abuse, and this is out of the PFA standards, which are adopted by the Protection from Stalking standards, and that's KSA 60-3106A. Prove the allegation of abuse, or in this case stalking, by a preponderance of the evidence, and the defendant shall have an opportunity to present evidence on the defendant's behalf. The two cases that I researched specifically are Barnett v. Barnett, which is 945 Pacific 2nd, 870, and Paida, P-A-I-D-A, versus Leach, L-E-A-C-H, 260 Can, 292. And that is 917 Pacific 2nd, 1342, decided in 1996. So I went ahead and looked that up. I don't think there's a light most favorable to either party. It is the allegations of abuse by the preponderance of the evidence more likely than not. There is no requirement beyond a reasonable doubt. In this case, there are several issues ramping up. His last email to me is not anything that has to do with an issue, but just purely an email out of spite at the end of that hearing. Again, I don't look at anything that's online, and I establish my issues and how I see this defendant on our interactions with his emails to me and the personal interactions that he has had with me. He admits that a good chunk of his activity is activist in nature. He and his attorney claims journalism, and he's going to argue that he is a journalist. They are not recognized by the Kansas Press Association or a member thereof. He is not.
The council, are they required to be
No.
journalists?
No.
Okay.
He is not a class media, as he admitted on the stand. He claims to be a citizen journalist. Well, that's some term that's been made up. And he admits that this is trying to influence me as the prosecutor. Targeting me as the prosecutor could be looked at as trying to influence me in my job. My job is already hard. I spend hours doing my job. Sometimes I am supposed to take the emotion out of my job, which I do almost every day. There's times where I have to try to take the emotion out. You know that in the court system, that's our job, to take emotion out of this. He has...
Let me interrupt you for a moment.
Yes.
Now, you indicated that in regards to trying to influence your decision. Isn't that done in various forms that citizens do in regards to that? I mean, we're not talking about bribery. We're not talking about kidnapping a dear one and said, do this or else. These were emails and statements that were made in public places.
Yes.
Or emails that were sent to your address. How is that different than if somebody writes a letter to the editor and they, saying this decision should be made or being critical of a prosecutor's decision?
So, Judge, I have had letters to the editor written on specific cases. People didn't have all of the facts. We have all the facts when we're prosecuting. In fact, there's a lot of times where the prosecutor has facts we can't give the court or we can't say to a jury. We're limited and barred so much. For instance, we're not even allowed to recite the criminal history of a defendant in a criminal case unless it's a conviction of dishonesty. They could be convicted of the same thing 6 times, and we can't tell a jury that.
But can't a citizen or a person do that? I mean,
he can put anything on his media presence he wants. If it's not targeted to me directly, as the Phelps case says, if it's not directly targeted to the prosecutor or to the person who is the intended victim, then we don't have a right to go out there and say, oh, they can't put it on their own page out there. That's why I don't look at his page. I don't care to. I don't want to give them another count on their views.
Let me stop you for a minute. We're talking, the issue has to do, constitutionally protected activity is not included within the meaning of course of conduct.
Correct.
And what I'm asking about is there a place where there's a line that crosses over in regards to it? There's certain things that we see and has happened in all jurisdictions where prosecutors are being criticized by either other citizens, the press themselves, and so forth. It's not always fair. It's not always accurate.
Nope.
But they're protected. Aren't those protected speeches?
The speech itself can be protected, especially his own on his own media, where he thinks he's being a journalist online or activist online. But
Where
when
does it cross the line
it crosses,
here?
it crosses the line here when he's addressing things that aren't part of my job. It crosses the line here when he starts having physical contact with me, with the door. It crosses the line when he is invading my personal space. When someone does something that is not in our personal space, that is different from crossing into our personal space. So, in this case, yanking the door out of my hand, getting within a couple of feet of me at the jury trial after he already has noticed this case is pending, coming up and the way I viewed it, he walks over towards these doors and then he dashes behind me and he comes within a foot of me. That scares me. It's a physical presence. They're crossing the line of, he's crossing the line of what he can do verbally when it turns into physically. And so I believe as a prosecutor, yes, we do have to put up with a lot of verbal abuse. And I have put up with a lot of verbal abuse over the years. But when it comes to our physical safety, that's when it crosses the line. When it comes to being the activist activity turns into threatening us, threatening our careers, threatening everything. Now, he can go, they've made a complaint, and I answered it, and it was dismissed.
Hold on, just a minute. The part of the request in regards to the stalking is to have no contact, correct?
Correct.
All right. You are a public prosecutor. A lot of your business is conducted in a public courtroom and so forth. Where does that line, or should there be a line in regards to an individual being in court and watching court proceedings or commenting, particularly if it's on a website or a published article, there. I mean, we're not talking about an ex-husband and an ex-wife where they don't have to cross paths.
Correct. So
What is the relief there in the unique situation in regards to a prosecutor and the defendant in this case?
in State v. Smith, 57 Canap 2nd, 312, which is 452 Pacific 3rd, 382, the case says the most narrowly tailored relief. And so he's already been told if he's got a quorum request and he wants something, that the form is with Mr. Dean or the county clerk. They fill that out, they send it in, and County Councilor Dean will deal with their quorum request. There's no reason for him to have to contact me for a quorum request. He's already been told the way to do that. That's why those quorum request emails are in there, because he basically
My question, though, is in regards to attending a trial. Because
if he's going to be present at a trial in a public courtroom, then he can be in the public courtroom. He has to follow the rules of the media, the presence in the public. But as far as coming up behind, normally this is the plaintiff, and I know Mr. Baker didn't know that, and normally I sit at this table as the state. So if Mr. Araby wants to come watch a trial and he wants to be on this side of the room behind the defendant, I don't care. I'm going to have extra security for the Walker trial again, and I'm sure he wants to watch the Walker trial. But in the hallway, if I'm down here in the judge's chambers, because we've been meeting with the judge, he shouldn't be coming all the way down that hallway towards me. He can stay over here near the clerk's office window. He could have been there to look at the clerk's office. There was no reason to come on down the hallway and stand right behind me.
please be specific then as to what relief you're asking this court to give based upon the statements that you just made.
Specifically, not sending any messages to me that are not a public type message, like he can make comments in the media all he wants. It's specific messages to me that are specific, not part of my job. To coming near me in the courtroom or being in this hallway next to me trying to come into my office. If he has a question about the case, it can be submitted without any comment to me about me or threatening towards me. A simple question. He doesn't need to be making specific comments or threats towards me. The other thing is, I am down a long hallway in Greenwood, and I know you're aware of the Greenwood Courthouse. So down that long hallway, there's nothing down there but the Kansas State Extension Office and my office. There's no reason to be down there. There's a secure stairwell for the prosecutor to get up and down from the courtroom. He doesn't need to be in that secure stairwell. There's no exit at the top if you don't have a key. So not being near my office in Greenwood, if he's up here at the clerk's office, to not be messing with me or my door, not following me, not coming close to me, so that my person is safer and feeling safer, that he's not going to run up behind me like he did at the Walker trial and stand 2 feet behind me. I've expressed I can't watch my back and do my job at the same time, which is why I've had security to help Sheriff Walker not have to put an extra person on me when we only have 4 deputies. This is not a county like Johnson County or Douglas County that has 20 prosecutors. We have 1, and that's me, and I have to hire someone to replace me for a jury trial. It's very expensive to do so, but we do it. So what I'm asking very specifically is, don't be banging on my office door. Don't approach me when I'm down here at the judge's chambers or if I'm outside my office. Don't approach me in the courtroom. If he's here for a public trial, he needs to stay over behind the defendant that's closest to the door. Not to be directly sending me messages. If there's something that has to do with a question about a case, they can submit a quarrel request. We can answer it. That's absolutely fine. Most of my cases are no public comment. We've had homicides, and I've had to draft public media releases. He can be added to that list if he asks. I'm more than happy to put him on the public media release list if that's what he wants. But for my personal safety, my house, my boyfriend's house, and my personal offices and vehicles. And I have more than 1 vehicle, as you know, but because I drive them here to the courthouse. But my vehicles, my parking spot, I would appreciate him not being near those areas. That is the most narrowly tailored things that I can ask for.
Anything else? Counsel, I'm going to give you a chance to hear. I need to take a brief recess to make a phone call. All right, we're back on the record. Counsel, I've given you some discussion in regards to time constraints. That phone call took care of that, so take your time. I don't want to keep you longer than you need to, but I'm not under a time constraint now. So thank you for your indulgence. Let the record reflect that the parties are still present and we're ready for closing of the defendant.
Well, Your Honor, Jill Gillette, from the beginning, has targeted Michael Irving. She did it in the Walker case based on pure speculation. She wanted breathtaking relief without personal jurisdiction over him. Wanted him fined and police escort and all of that. I mean, that was the most frivolous motion. No personal jurisdiction, but I want you, Judge, to find that guy, to excommunicate him from the courthouse.
Hold on. Now that's a matter before Judge Rickey on the Walker.
All I'm saying is, it's going to her credibility.
Okay.
So she was not successful. She said, well, in the Walker case, well, he sent those core requests, and he's been here, and they're giving me bad publicity. That's all this is about. And it didn't work. So what does she do? She's still got a little prosecutor hat on, and then she comes around here and says, well, I'll file a pro se motion. Now, let's talk about first things first. She perjured herself today. In no uncertain terms, she lied. She lied. She lied about the deputy coming up about the door. I mean, if you would have read that petition, you would have thought this guy was a maniac. All the things she said. Okay, well, let's get the videos out there. And the worst one, the most blatant lie, was that thing about going out to a car. Now, dadgum, she wasn't vague about that at all. No, he followed me out there. Why, he blocked me, and he looked in my window. I mean, that's like a dream. You know, she says, well, I thought I remembered that. That is perjury. That is unethical. That was a flat lie. And you know what? If she lied about that and lied about the other, what else is she lying about? Now, let's get to the other parts. Judge, your task here, the standard is a reasonable, an objective standard. Continuity of purpose that would cause a reasonable person to suffer substantial emotional distress. Substantial emotional distress. Not inconvenience, not irritation, not irritation. Substantial emotional distress. Nothing you saw in any of those videos would have done that. Nothing in those emails remotely would have caused anyone substantial emotional distress. Oh, he talked about my duck. Oh, he asked questions about my duck. Are you kidding me? Asking questions is protected. I am really astounded. She had all kinds of time. She said she worked on that complaint since July. Had been saving it up. Saving it up. And she says, well, I listed all those events, 9 of them, and there's a reason she took them out of order. She didn't list them in chronological order in her petition. She started out with other stuff. But when you list in chronology, the first 2, she says, oh, those were events. Oh, no, they're not. They don't. Oh, okay, never mind. Never mind. Just, there's nothing in any of those emails. Nothing. He wrote those to the commissioners about business, and he copied her, asking her about a debt that the police had to come and take from her. That is a matter of public concern. The community knew about it. The chief law enforcement officer of Goat County had her dadgum stolen duck. That's news. She can be questioned about it. And she says, how dare you? She says, well, can you imagine if this was the Kansas City Star and she's asking for the same relief? Because that's really what it is. There's no difference. The media today is different. People are getting their news from blogs, from YouTube, from Joe Rogan, to influencers. There's all kinds of journalism that's going on today that is not what we call the traditional journalism. And that's what's happening in these YouTubes. These fellows go out and they investigate, they report, they have an issue with the button out there. But then they had an issue, and he went to the prosecutor. They had an issue about what she tried to do to him ex parte. You can't talk to the prosecutor about that? You're trying to get all that relief against me, Miss Gillette? Ex parte without due process? If you can't ask her about that, if that's not newsworthy, but think about the timing. Just think about that. All that wrapped up, July, September, and she says, no, I'll just keep it in my back pocket. No, I'm so terrified. I'm so, but I'm not doing anything about it. Oh no, what broke the camel's back was the Walker. The Walker motion in which she got chastised, sloppy, and then she got that count 1 dismissed, and these fellas publicized that, and that was embarrassing. That was the straw that broke the camel's back, and by golly, I'm gonna pull the trigger. November 1st, I'm gonna file. There's no reason. The timing is all there. You would have to find, out of all that, she acts like this is a PFA. It's not. You would have to find 2 separate acts that have no legitimate purpose. You can't do it. But not from any legitimate purpose. You would have to find that in those 2 separate acts, that each one would have caused a reasonable person. How about a reasonable person with a clock strapped to their chest with a bullet in it? Remember, she's got that. She talks about that incident where he dropped the phone. That guy was there and another officer was there, and she's got a clock. No reasonable person don't be afraid. She's just irritated about the bad.
Hold on. I've seen officers testify many times in regards to, it doesn't matter that they've got body armor, that they've got weapons. If somebody is doing things, isn't it reasonable that a person can be afraid, even if they've got something else?
That's not the, to be afraid, yeah, but that's not this standard. That's not this standard. Him dropping his phone wouldn't cause someone substantial emotional distress, right? You gotta have that one. It wouldn't cause a reasonable person to fear for her safety. Now, when you got a Glock on your chest and 2 police on either side of you, she says, well, they talked to me at that elevator. Well, there's old Joe Love right there between her and them. She got that Glock on her. And they're talking in a normal voice. You think that caused substantial emotional distress? No way. No way. Fear for her safety? No way. Now, seriously alarmed, I can keep going through the list. Seriously alarmed, annoyed, tormented, or terrorized. Guess what? If she doesn't want to be a public figure and to answer questions, she even complained about her residential address that is in the public record. Her car is parked out there. I saw it. It's all public. Now, nothing she has complained. All she's done is just gather up all the incidences that had happened, connected that, and she says, there it is. I was scared each time. And that's not the standard. Now let's just talk about that. She's doing counseling. She has anxiety problems. She's not your normal, reasonable person.
Well, counsel, in the training, the CLEs that I've seen, attorneys and judges have a substantial amount of those sort of issues.
It may be. It's still the reasonable person standard. So all this talk about her being subjectively, all that's irrelevant. You have to look at it through the reasonable person standard. So the reasonable person who's not having anxiety problems or whatever, but a reasonable person not going to have substantial emotional distress because somebody dropped a phone next to him while two policemen have got a Glock there.
But doesn't the evidence reflect your client right outside of the door, her private office door, the one that's secured?
Yeah.
Not the double door, referring to her as a, quote, dumb bitch, unquote?
Yeah, he cussed her. And you'll see there is nothing. I encourage you to read the Loeb decision. Because that is, saying dumb bitch is protected activity. It's not a fire in the theater. I can cuss an officer all day long and it's protected. I can give you case law all day long. In fact, that Sampson case.
Well, is there a difference then between what something may be protected speech that you're allowed to do, but then what about the perception of the person that's being directed at?
Doesn't matter. Doesn't matter, Judge. The course of conduct is, and Loeb will tell you that, just because he was uncivil or he cursed her. Now, think about this. Dumb bitch. Okay, we all have heard that phrase.
How things are said makes a big difference.
All right, so even if he's angry, it doesn't count. It's subjective, and that's not the issue. You're going to read in Loeb, and they've gone through this constitutional analysis, and one of the reasons they've done that is you'll not find it in case law where a public official is seeking relief against the media. It just doesn't happen. So you get the rare case, which I've cited to you, and they've overturned the district court, and they said, look, you're restraining speech. You were dead on. The idea that she doesn't want anybody to ask her, don't ask me about a duck, well, that's not your personal life. You're a public official. So, and really, one word, calling her one word, that would cause her substantial emotion for a reasonable person. You can't say that. You can't. And the fact is, Judge, that you saw him, he was never yelling. Never. He was screaming coming up those stairs. A lie again. She lied every way. In fact, the only questions that were coming up those stairs was out of Dr. Spees. But see, in her mind, you just lump it all together. Lump it all together. Here's something. She says Dr. Spees did not violate the stalking right. He was right there with Mr. Irving. Well, if he didn't violate anything, neither did he. So, she's got it out for him, no doubt. No doubt. She's done it, and you would have to find these elements, and you can't do it. You could not say he has no legitimate a reason for the statements he made to her, or that he asked her questions about a duck, which is a matter of public concern.
I think we've overdone the duck.
Oh, yes, I do too, and it was a subject of a long dissertation, but it keeps coming up. Judge, you cannot possibly say there were two events that meet each element that had no legitimate purpose and was not constitutionally protected. Cussing is constitutionally protected. He uttered no threats of harm to her. He never made physical contact with her. He never said anything of that nature. And in fact, when I asked the officers, hey, did you see him being threatened? No, didn't look threatening to me. You can't find it, Judge. It's not here. It's not here. And you're just going to have to deny, I'm going to ask that you deny this petition.
Okay. And we've got protected speech and constitutional things there. But does that mean that a person just gets to keep asking the same questions time after time after time?
Sure does. Sure does. That's what the press does. Mr. President, or any public figure. That just goes with the, I know.
The president's got a bunch of folks to take care of him, too.
It's still a public figure, and there's no different species, as she thinks. There's not a public figure for purposes of Elk County versus Johnson County. If you're a public figure,
Hold on a minute, hold on. Can a public official say, I can't answer that question, or I don't want to, and then have it dropped? Why not?
because the freedom of speech and freedom of press.
Counsel, wouldn't you agree that there are statutes that deal with what information can be released, particularly in regards to if there's a warrant for somebody?
No, I get that, but that's not this case.
Well, wasn't there tons of questions in regards to whether your client and the doctor had been charged?
It's still a legitimate purpose to ask. Now you say, well, she said stop it. It doesn't mean that it forfeits its protected activity. It's still protected speech. You think, well, don't quit asking. Well, he doesn't. It doesn't lose its protected value just because. The courts are specific. They say it's threats of harm, fire, all that. Just because I ask questions that you don't want to answer doesn't mean it's not protected speech. And if it irritates you,
Well, okay, so the question may not be, may be protected, but how far do we take this? Please, let me.
Sure.
Is if somebody's going and asking a public official things, they don't get the answer they like or want, maybe it can't be answered, for whatever reason. Does somebody, because they of the constitutional right to the media, or however you want to phrase it, how far can they follow? How close can they get without, at some point there seems to be some merit in regards to where a person could reasonably be concerned for their safety.
You may be, yes, you're asking that question. This statute puts it differently. This says, that's not the question it's not that they said no, but my repeated question would cause you substantial emotional distress. That's where you're stuck with that. Would it put someone in reasonable physical harm? Those are two elements that you got to overlay. I get your other one, but that doesn't overcome those two, right? And I would suggest to you that media, just because they say, and you know what that would turn? Every core request that's denied into a possible stalking. I made a core request, and they said no, we'll make another one. Well, you're stalking us. I said no, and no means no, we can't give it. I would be lots of stalking crimes. You can ask. That is a protected, you can petition government, you can ask, I can ask the official, and if you say no comment, who knows, tomorrow you may want to make a comment, or you may change your mind. Who knows? But the idea that they would say, hey, why did you charge us? You'd want to know, I'd want to know. And she said, well, I'm going to tell you. You saw them make efforts. They're not here just busting her up. They went to the clerk, they went to the county commission, they went everywhere. She wasn't the target.
Okay, counsel, now what, we say there's a procedure and they go through it and the court signs off on a warrant. There's lots of people that may have access in that knowledge. You mentioned the clerk, sheriff's office dispatcher, prosecutor. All these different people know, but we're restricted in regards to what that information can be given out until that warrant is served.
Well, that may be. I don't know that. But the fact that but the thing is, even if it is, you say, well, I'm prohibited by law from telling you. And you say, well, once I tell you that, you better not ask me another question. Now
Well, isn't there a time then where it crosses over into harassment? Because you mentioned a clerk.
I got it.
Okay, and so the clerk can say certain things and can't say certain things. So does that mean an individual that doesn't, that when she won't answer a question, that can follow her home, asking her that question all the while?
Let's think about that. When they said they didn't know, they didn't pester those gals. They said, we don't know. Thank you. Thanks. But the person that does know is sitting right here. I mean, they ask. But here's the thing. The statute requires far more than just being irritated. It has to cause substantial emotional distress. I mean, you're impinging upon free speech. And so they raise this barrier, substantial emotional distress. You've been in court. You've heard it. I had my feelings hurt, whatever. That's not even emotional distress. It's substantial emotional distress to a reasonable person. And then were you in fear of your physical safety? No. You don't get it here. Now, so I can't help you. This is what the legislature said would constitute stalking. And they measured free speech and legitimate purpose, constitutionally protected activity. And this is not a private citizen. This is a public figure. Overlay that. So we're not going to her. We didn't go to her house. We didn't go to Greenwood. We've not done all that. You see the purpose. It's there. You'd have to find there was no legitimate purpose. And to say that you could never ask when somebody says no comment? I mean, there is a reason that they got called and said, hey, we're charging you, buddy. You guys are poo-pooing in our lunchbox. And I don't like the publicity. Why did she wait all that time? Why? I told you why.
Here, let me ask you this. Is there a line in regards to the media and an advocate? Because I'm going to refer to your client's email from October the 30th.
Read the part.
Pardon?
I'm sorry, whatever.
And that's the one where it says, disrespectfully, Michael Herbe. That's how it ends. But that seems to me to be more of trying to be an advocate to get her to change a decision she's made, that she's entrusted to make as the prosecutor.
Still protected activity, Judge. He can say disrespectful. It's not unprotected speech. That's what you have to look at. What is protected and not protected? The realm of protected speech is I can be uncivil, I can be rude. I mean, this is what law goes through. It's a Hornbook law. I can be boorish. I can be rude. But that's still protected. And in fact, that's part of the political process.
So are there any bounds?
The bounds, well, in this case, the bounds are no legitimate purpose, can't be, it's unprotected, and then it has to be substantial emotional distress and put them in fear. That's the overlay. So we're kind of talking esoteric on the line, but that's the line. So you say there's a line, but this is the line. This is the line. And you're not going to be able to say he did two things that did all those, each one did all those things. Had no legitimate purpose. It may have been irritating to her. You may say, well, she didn't have to answer. She didn't have to answer. She said no comment. And by law, she wasn't required, but she could. She could comment. She's not prohibited. They can give documents on an ongoing investigation under CORA. They're not barred from that. They're not barred. They have discretion. She could have said, yeah, we're thinking about that. I mean,
But as a practical matter, I've never seen a prosecutor, when they're looking at an active investigation, where they're giving out the police reports.
all I'm saying is, they're not barred by law from doing it. They can have discretion. There's no law that says she couldn't say that. She's not, it's not a HIPAA violation or something like that. Okay, she's got the right. You don't have to, but that doesn't mean she's barred from doing it. They do it all the time. And, here's the other part we haven't really talked about, and it goes to credibility. She made a big deal about these security cameras. Oh, and this was how to get these guys. Because, boy, if you know about these security cameras, and that's what these fellows are up to. They want all this core requests. They want these security cameras. And then in this case, she gives us a security camera from Sheriff Walker, courtesy. Walker, she said you can't use them in a case. Walker should have objected if he thought it was a, closed case. But he didn't do it. Personal courtesy to the county prosecutor. So so you're still, Judge, stuck with the statute. All the questions you're asking are good, but they're not you have to overlay it here. 2 events that did each one of those things that had no legitimate purpose, was not constitutional protected speech, and that it caused the person to be in fear for her safety, and that would cause a reasonable person to suffer substantial emotional distress. I urge you to read that Lowe decision, because it is a case that captures this same scenario that is rare. And read through that. They use the same identical language. They go through the constitutional analysis. In the end, they say you can't, this is public. It's a different rule that applies when you've got a public figure and the media, and particularly a public figure. And think of the breathtaking relief, the restraint, a prior restraint of speech. That's what she wants. Now, Judge, I don't think there is remotely a case here, not under this guideline.
And this may be getting a little far afield, but I understand your argument in regards to, the press doesn't have to be necessarily accurate. They don't have to be fair. They don't have to, they can be an advocate. And if they're putting it on YouTube or printing it out, whatever, isn't it different then if that individual is within arm's reach of you?
No. Geraldo would never get any stories. That's,
that's the journalist that got nose buzzed.
Well, that may be, but I'm just saying journalists all the time, hey, you have a comment? Here's a microphone, and they grab them as they're going into the courthouse. I just want you to think about the restraint. They didn't do anything other than just be out in this hallway. They did go outside, which they're allowed to do, but it wasn't like she said. And when she turned the corner and went to his car, he didn't go down there like she said. He gave her space. When she went to the elevator, he didn't go. When she went in her office, he didn't go. She might have something to talk about if he tried to bust in the office, but he's just out in the hallway, outside. That's protected activity, Judge. He has a right to associate, and he has a right to ask annoying questions that irritate her. She's embarrassed. She doesn't like the bad publicity. Walker, she couldn't get it done, so she recalibrates, and she's over here doing it. So, Judge.
Counsel, I can't help but to think about circumstances. If there's an attorney trying a case, and it doesn't have to be a criminal case, it could be a divorce case, and then, emotions get high. And particularly in small counties, we don't have a lot of space. We don't have a lot of public areas. We don't have a lot of areas where an attorney can kind of get away. Here, this courthouse is an excellent example. How do we maintain the peace in regards to those situations?
Well, again, you're not talking about public figures, okay?
Well, could be.
Well, I mean, we're talking in hypotheticals.
Wouldn't it, an attorney who does high publicity cases, sues people?
Boy, I don't think you'd be well, I guess you could try it, but now we're into New York Sullivan, who's a public figure or not. She's already admitted it. She's a public figure. She's already admitted they're media. She admitted it on the stand. She admitted it in the walker. So let's just take those two concepts. So the hypotheticals, you got to land on all fours with what you're dealing with. And we can parlay this from, if that's Kansas City Star, and you're telling the Kansas City Star you can't ask that woman any more questions. And don't you dare, have an investigative reporter. I mean, you see him come up to the door. Hey, I heard, all that. So the legislature has weighed all that and put that here, and they put a high bar, a very high bar. It doesn't matter her sensibilities. It's a reasonable person. And it has to be a substantial emotional distress. And it has to put her in physical fear of her own safety. None of this does that for each event. It just doesn't. And the way she tried to clean that up, she said, well, I'm calm. And she was calm. You didn't see her look distressed at all. You see her, no? She's not screaming, she's not doing it. She says, so everything you saw says, she says she's trained EMT, she's law enforcement. I mean, she's dealt with this, she says, I've had it, I've got to have thick skin. So you don't see anything in those videos that says she's even distressed. And she's got the time, in fact, she's got the time to wag her finger and say, don't record me. No. And lied about who could record. You can't record me out here. And I said no comment. So she's talking to him. She's not huddled in fear with Joe. None of that. So you think, well, I just take her word. She's calm on the outside, but she's just, terrible on the inside. That's not what you saw. That's not what you saw. So if you would try to do a subjective, that's not what the video evidence is. Now, I think you have to look at credibility. I really do. And you're the judge of that. And you heard these men, Dr. Spies and Mr. Irving, come up. And everything they said was validated. The videos that we have, validated. Everything they said was true. Everything. So, I think you can do that as well. So, Judge, I'm going to ask you to deny this petition.
Thank you. I'll allow brief rebuttal.
Judge, I'll keep it really brief. He keeps pounding the log versus book case that he gave us. I would point you to page 8. The respondent made no threats nor any threatening gestures toward her. I want to repeat that. No threats nor any threatening gestures towards her. Number 1, yanking the door out of my hand caused me 3 days of pain. 2, the 10/30/24 email triggered me to want to finally file this case. He's inaccurate. I didn't start this in July. I started gathering up the emails in mid-August. I started drafting this around September. And I was putting things together because things were amping up with Mr. Araby, and I guess he goes by Dr. Spies, coming down here. There's no legitimate purpose in yanking the door out of my hand. The 10/30/24 email has no legitimate purpose. 3, the threat to follow me for my whole career. I don't care what he puts in the media. I get good press and bad press. I'm on YouTube every day. People make comments, good and bad. I don't go look at them. People tell me about them, but I don't care. I don't follow it. I know who I am inside, and I know that I try to do my best in my job as a prosecutor, and it's a very, very, very difficult job. Mr. Baker has zealously advocated for his clients, but he's wholly inaccurate in a lot of things. They did not request for a case. There's a big difference between them and the Star. As I was taught in law school, and I hope Mr. Baker received the same education, there are different levels between national, state, and local representatives. I'm a local representative. I'm not a state representative. I'm not the Attorney General of Kansas. I work in two very small rural counties who can barely afford to have attorneys on their own. And so I work in two counties where there is next to no attorneys. We have two in my two counties that are actually active besides.
Counsel, I would ask this be, this is background, this isn't rebuttal
Right.
to his arguments. So if you don't have anything further.
I have a couple more things. Number 4, he followed me outside. There's no legitimate purpose in that. And number 5, he came towards me at the judge's chambers. There is more than 2 events here. It is not each specific event that has to raise fear. The law says the course of conduct has to create the fear. Not one event, not this event, the course of conduct added up together creates the course of what causes fear. So when we go from beginning to end,
Counsel. Based upon one of the things you said, is why can't an individual go outside and ask questions? I mean, we see that all the time in regards to people that are a public official or just a public, somebody that's
he'd already asked me inside the
popular.
courthouse. There was no reason to follow me.
Well, is that even the test?
I
There's
feel
no
that
reason to?
I didn't feel like there was a reason for him to follow me outside. He asked me in the courthouse, I answered it, should have ended there. There's no legitimate reason for yanking the door out of my hand. There's no legitimate reason to approach me at the judge's chambers. He's not coming down there to ask me a question. He's not coming down there to do anything that had to do with court business. There was no reason to come to the judge's chambers door where I came out. My sister just died. She was literally found dead at 7 o'clock in the morning or a little thereafter. I literally found out at 7:48 a.m. when I got out of my car.
Now, we're talking facts and not a rebuttal here on that, so.
Right, but there is not a legitimate purpose for those things. The email on 10:30 has no legitimate purpose. It has nothing to do with bad embarrassment. It has to do with him personally messaging me. Nothing but awful stuff. But the yanking the door out of my hand, the threat to follow me for my whole career, following me outside and coming towards me at the judge's chambers, I would say those do not serve a legitimate purpose. He believes he can cross the line as an activist and that it is a risk for him to do so. Coming towards me down here at the judge's chambers, there's no reason for him to do it. He already had this served on him, and he still did it. Yes, I was very upset that morning over my sister, but I stayed calm, kept my mind about me, but him dropping his phone right behind me when I've already been hurt by him absolutely causes fear and is the course of conduct, not the individual event. Mr. Baker is misstating the law. It is the course of conduct, and there are more than one purpose here. The door coming towards me at the judge's chambers are 2 of the most blatant ones. They are threats of gesture, him coming towards me with no legitimate purpose, and him yanking a door out of my hand. You cannot find a legitimate purpose for either of those.
All right. Counsel, I know it's been late. I would like to review these materials. I'll try not to take very long, but I'd like to get a decision tonight. And can you bear with me?
Thank you.
Yes.
Ms. Gillette?
Yes, Your Honor.
Okay, we're gonna be in recess. And all right, we're back in the courtroom. The parties appear as before. I want to make sure we have all the exhibits, everything first. So, in regards to the petitioner's case, I have 1, 2, one through 7, and 11 and 12.
Correct.
And the other numbers aren't there?
No, those were additional videos we didn't play.
Okay. So those are all present here, got those. In regards to defendant's exhibits, which have the yellow sticker, actually I have two sets here on the document. So I'll return one set to council. And it goes A through E.
Correct.
F
Yes.
is a case out of Florida. I'm not going to accept that as an exhibit. That was, as I understood it, just a demonstrative, or excuse me, a copy for the court to review. Council had that as well. And then there is G, which is also a case, so it's not uh, it's not admitted. That is a Kansas Court of Appeals decision, which is a 1977. That's the Sampson case. Sampson versus Sanborn. All right. Is there anything that I've overlooked in regards to exhibits that you need to address?
I don't have anything in regards to exhibits. I do have one comment regarding the case that he brought in because I took the time to read it while you were reading items as well.
It's not. It's not something that, frankly, was helpful to the court in regards to making my decision.
I believe the case was miscited to the judge as to the court as to what it actually says.
We're going to hear
That
argument
was
about that.
misconstrued.
I mean, really?
No, we're like I said, that wasn't something that I found help or considered in my reaching my ruling. All right. All right. The petitioner requests finding of stalking under the protection from stalking statute, which is generally under KSA 60-31, A01 subsection B, at SEEK. And for the purposes of this hearing, there's no allegations of sexual assault, there's no allegations of human trafficking, so I'm not going to go through those and addressing them. But the evidence has to be considered by a preponderance of the evidence. In regards to the defendant's motion to dismiss at the conclusion of the plaintiff's evidence, that is denied. That has the effect of basically, I'm considering all of the evidence that was submitted by the defense as well as the plaintiff. So we've gone through the exhibits. All right. Stalking is defined through this statute: an intentional harassment of another person that places the other person in reasonable fear for their safety. Harassment means a knowing and intentional course of conduct directed at a specific person that seriously alarms, annoys, torments, or terrorizes a person, and that serves no legitimate purpose. All right. So it does call for a course of conduct, which is defined as conduct consisting of two or more separate acts over a period of time, however short, evidencing a continuity of purpose which would cause a reasonable person to suffer substantial emotional distress. Constitutionally protected activity is not included within the meaning of, quote, course of conduct, unquote. In reviewing this, I'm going to go back to the petition. go through that. And it does request for a description in regards to the events that they claim. These are marked as, in the petition as incident 1 through 9. Once I announce my decision, if there's any post-trial motions, then I'll take those up. But once we're adjourned, how I typically do this type of case, PFAs, is we permit we ask the defense to wait a bit. The plaintiff leaves, and then to give some space. Any objection with that?
No.
All right. All right. I'm not going to go necessarily line by line with these. In regards to petition referred to as Incident 1 on July 29th, 2024, that refers to the defendant following the plaintiff to office to the commission meeting room and then to the car after. That was also, there was video that was introduced, described from doctors. Is it Spieth or Spieth?
I think it's fees.
With an S? Okay, thank you. I viewed the video, and it does not contain the evidence that I feel, by preponderance of the evidence, necessary to find that incident occurred in regards to one of the course of conduct incidents. The defendant did follow the plaintiff outside. However, that video does not reflect him approaching the plaintiff outside nor her vehicle. Whether or not there's a reason to follow the plaintiff to her car or no reason to approach outside the courthouse does not bar an individual from doing so. There's issues, constitutional issues in regards to the freedom of the press and protected speech, but these are public areas. These are not an area where there would be any expectation of privacy. If it was an officer following out that same way, I wouldn't see a problem with it. I wouldn't see a problem with it in regards to a private investigator. It's not, sometimes there's perception. So there can be sometimes widely different views in regards to descriptions of an event. But I do not find that was qualified as a harassment under the definition that would contribute to the course of conduct. Regards to incident 2, that would be the incident on September 9th, 2024. That dealt with the commission meeting and then the defendant asking questions about the duck. There was nothing in regards to the questioning that I found to be harassing, unpleasant perhaps, but not harassing and not that would qualify under a course of conduct. The description in regards to the door, and I tried to give a description for the record in regards to the doorway that we're talking about. And I'll go over that a little bit. But there are double doors at both ends of the corridor that at this courthouse. Those doors come open very easily. They can swing very easily. and do. Additionally, there are signs that indicate those doors will be closed. It is not uncommon for individuals in the courthouse to be pulling that door shut as they walk through it. Nothing in, you know, as I indicated before, some of these things I can't separate from my daily activities at the courthouse. It's just something we do. Um, so there can be a different perception in regards to what's occurring there and what is characterized by the plaintiff and what's characterized by the defendant. I don't find that there was a yanking of the door out of the plaintiff's hand. I don't find that there was screaming profanities through that entire time. Uh, Certainly, there were statements that, in regards to the name calling, that I thought is inappropriate, rude, insulting, but I don't find that it wouldn't be constitutionally protected. So I don't find that the incident described as incident number 2 qualifies for a course of conduct. Number 3, it again discusses the issue in regards to the duck and the situation there. And it brings up points in regards to somebody investigating or looking into things. That's not something that a person is barred to do. People research other individuals all the time. Private investigators, and there was no showing that there was something that was done that would have violated any criminal statute that I could see or find, such as criminal trespassing or being in somebody's home taking photographs, which we've seen in some stalking cases, things along those lines. So even if it's characterized as snooping around, asking about a personal life, again, I don't find that to be something that would be actionable or constitute harassment in regards to that. I can see how that comment, that question, would be concerning, not because of the duck itself in the matter. And part of these things, and I'll go through these with incident 4, is an email and the words, threaten. There's been the use of the term threatening a lot here, not just by the plaintiff, but the defendant, individuals that apparently are in agreement with the defendant in regards to things. Characterizing whether somebody's investigating that, that people characterize it as a threat, that doesn't constitute a threat necessarily. So I don't find that incident 4 is with the indicates a threatening to pry into the career for the rest of someone's life. People can and do research individuals and follow persons' careers, not always in a kind way, but again, that doesn't mean it's not, that they're not allowed to do so. It is protected. Incident number 5, email from August 18th. Whether or not the defendant has an understanding of what it's like to be a county attorney, most people don't, unless they've done that or worked in the criminal justice system. But that's not individuals. In regards, individuals keep trying to intervene in investigations in the cases constantly, and there's a balance to be had. There's people that request people prosecuted, not prosecuted. And times that's uncomfortable to tell people what the decision is, but that's something that somewhat comes with the territory. So I don't find that even exists as now. The step number 9, then another email didn't find anything that constitutes a threat or harassment under the course of conduct. Same with 6 and 7, and that is the emails of July 9th and July 3. Number 8, incident 8, the July 21st email. Again, I did not interpret the statements of the defendant to be a threat and things that could be legally said, whether or not they're appropriate in the broader sense or rude. Um, that's not the test that has to be met here. Incident number 9, which was the exhibit of G. Well, no, let's see, it was the October 30th email. That seemed very apparent that Mr. or the defendant was really working as an advocate for Mr. Walker. And the defendant admitted as such up on the stand. I wish people wouldn't do that, frankly, particularly when they're not requested to. I don't know, but I don't find that it is harassment. Again, there were things that were said in there that could be viewed as offensive and probably deliberately so. But the defendant was trying to get the prosecutor to not prosecute Mr. Walker. County attorneys have a great deal of discretion in regards to the cases, and we try those to courts, we try those to juries. So I don't find that incident number 9 constitutes a harassment under course of conduct. Nor the following in the courthouse to the commission room and so forth. Again, things that I think could have been handled better, but that's not necessarily, that's certainly not the test. So those are the incidents that are referred to by the plaintiff. I do not find that 2 exist. Therefore, I do not find that the stalking should be granted. So I decline to do that. So the petition is denied. As I indicated earlier, there are times that their perception is not always the same. There are arguments made in regards to lying and perjury. I didn't find that to be the case. While certainly the evidence didn't support the petition, as I've already noted, I've seen worse instances where things were perceived, and honestly so, that weren't accurate in my view. So the petition is denied. Are there any other rulings that need to be made in regards to the petition?
No, Your Honor.
No.
So I made my decision. Other issues concerning the courthouse, I think need to be dealt with by the chief judge in regards to our trial judge. In regards to that, I've not given this. I think people need to understand, and there was definitely misstatements of law made by the defendant and some of his colleagues. But I, I, I would hope that individuals would, try to follow the law, and I think counsel should discuss with the defendant perhaps KSA 21-5905. And there are incidents concerning judges and prosecutors in regards to conduct. Very well. So we will be adjourned. I would ask that the plaintiff proceed out, that there be an escort for the plaintiff. Again, that is standard procedure. Is there other issues that we need?
Just one issue, Judge. The petitioner did subpoena documents from the sheriff. Usually when you subpoena, both sides gets those documents. I didn't get them. And I'd like just an instruction from you to say, whatever she got from the sheriff under that subpoena, that I'm entitled to receive those same.
Judge, you've already ruled that those are not being handed out, and I would ask that they not be.
And we're referring to the videos that were played, is that correct?
Well, yes, she subpoenaed. She's a private citizen. She's got possession of them. Now, I think if she gets possession of them, I also should get, it's a subpoenaed records. I don't know if she's going to appeal this. I don't know what's going to happen, but I believe that I'm entitled to whatever documents she received under subpoena. I should also get those, and I haven't been provided those, and I'd like those.
The only copy of the flash drive is in the court's hands. I do not have a copy of my own.
All of the records that Axon and everything that the sheriff produced for you, is that what you're representing to the court is in that thumb drive?
The extra videos we didn't play.
That's what I'm asking. So she's got other videos that she chose not to. That's why you've got a omission in those exhibit numbers. It's still, she's acknowledging she got more videos than what she put on that thumb drive. I just like what she got from the sheriff as a private citizen, and I also get those.
There's two flash drives I have, and that's it.
Hold on. To what purpose?
Well, I think I'm entitled to it under a subpoena. So when you subpoena records, both sides get them, whoever subpoenas. So the other part of it is, there may be an appeal, I don't know, but I think I'm still entitled to that. Judge, private citizen here has possession of all those records. And it cannot be fair that she can subpoena the sheriff and keep what she wants and give out the other. That's all I'm saying. It can't be, if she's got them, it can't be confidential. She's a private citizen.
The two videos that I have left, Judge, are on flash drives that the sheriff brought to the hearing. I didn't see any of them ahead of time. I didn't make any other copies. If those two flash drives actually belong to the sheriff, the only reason I have them is in case we needed them. They can be returned to the sheriff. I don't need them.
I'm going to order that they be kept in the court file as the exhibits. We don't have any large type, and I've got no problem with counsel viewing those. I'm not going to order that they be disseminated. unless it's for, uh, uh, you know, authorized in a, you know, another lawsuit or an appeal of some sort.
Or maybe a core request.
Well,
And see how they'd be private if he gave them to a private.
I'm not going to rule on court.
No, I understand that. I'm just talking out loud.
May I approach your,
All right, well, both counsel would approach. Okay, this is the stack. These are Mr. What's this?
these are the leaves that I want you.
Those are the copies.
Okay, so you got the original.
These are there were two sets of copies.
Yeah, I get it.
So I think, and if you guys want to look at them, make sure I got them all numbered correctly, but I'm returning those two cases that are F and G. And here's the,
This is theirs, those
Well, I
are.
appreciate that you.
I'm going to put those in with this baggie that's been provided. And so all of the thumb drives will be kept together. For the record, 8 and 9 were not admitted or viewed by the court. Again, I've got no problem with counsel viewing them, but I'm not allowing them to be disseminated. Absent another court order.
Thank you for taking the time.
All right. So we've got the defendants. Here's the plaintiffs.
I have to pack up my office, so I am escorted to my office and they leave the premises sometime.
Very well. So, there's an escort for there, and hopefully that won't ever be necessary, but, so Mr. Baker,
Yes, sir.
if you would have, and we're well past the hour for, the courthouse to be closed. Deputy, if everybody just go out the same doors, all I'd ask, so that we, north door. This building is something different. Okay, we're going to go off of it.
Thank you.
Try to say something.